On September 3rd, the Occupational Safety and Health Administration quietly issued an announcement in the Federal Register. It didn't catch much attention, but it is destined to have a profound impact on retaliation claims under the OSHA Act. We're going to talk about the retaliation claim changes to the OSHA Act under this new interpretation or revised interpretation on this, the September 22nd, 2021 episode of the OSHA 3030 with Manesh Rath. Hello, everyone. I'm Manesh Rath, and I'm a partner at the law firm Keller and Heckman here in Washington, D.C. I am an occupational safety and health law attorney. I've been engaged in this area of law for almost all of my 26 years of practice. And I got to say, I love it today as much as I did when I first began. And I'm joined today by my colleague, Taylor Johnson, who will be joining us by audio. Taylor, thank you very much for joining us. Important and central part of our OSHA law team here at Keller and Heckman.
A pleasure to be here as always, Manesh.
Well, Taylor, we've got an important topic today. All of the topics that we've covered in the past 98 episodes over the past 8 years have been libraried on our website, khlaw.com/OSHA3030. Many of them are still very instructive, very informative, very relevant to the in-house counsel or safety and health professional in corporate life. And that goes to some of the topics we covered 8 years ago and some of the topics we've covered earlier this year. So I encourage our attendees to, when they get the spare time, check them out. They're all still on our website. And the next invitation you get, please remember, as we've asked many times before, to forward the invitation for future OSHA 3030s onto others within your team or at other organizations who are responsible for OSHA law, either in-house counsel or safety and health professionals who could benefit from the kind of information that we put on every month without interruption for as a complimentary service to clients and friends of the firm. Okay, with that said, Taylor, why don't we start by talking about what we're going to talk about today?
Absolutely. And as you alluded to earlier, we've got a great agenda here today. First, we're going to provide an overview of the relevant provision of the OSHA Act that deals with retaliation. Then we'll launch into a review of OSHA's prior retaliation test. We're going to unpack the term but-for causation. It's a term that Manesh and I will be mentioning multiple times throughout the program, and so we wanted to just make sure that that the listeners were clear on what that means. We'll provide an analysis of OSHA's new test, as Manesh mentioned, which came out recently in the Federal Register. And we're going to examine Supreme Court precedent, so sort of the why OSHA is going this way with the new test and the support that they found for this change in Supreme Court precedent. And as always, we're going to end with some practical takeaways here for employers. And then after the program, we'll have our new section, Off the Record. It's a conversation for live participants only. And we actually have a bunch of great questions today from listeners, and we'll read those live on the air. And Manesh and I will provide some feedback. So make sure you stick around for that.
That's right. Some of our longest standing listeners have contributed questions, and some of our more recent additions to the OSHA 3030 community have pre-submitted some questions. So we're thankful to all of you who sent us questions ahead of time. And to be clear, this program is republished as a podcast, and it's also posted on YouTube with the slides and the video. So that is the recorded section of this program. But at the end, Taylor, as you said, we'll go off the record, no recordings, and just have a live webinar exchange with our community members who want to stick around, and we'll address those questions plus any others that people want to write in using the chat function. We'll just stick around for 10 minutes, so we might not have time for every question, but we'll certainly try to tackle some of the good ones, and we can try and deal with some of the others offline if necessary. So why don't we go and get into it? To start off with, the Occupational Safety and Health Act is where retaliation law under the OSHA Act arises. It is written into the Act, the original Act from 1970, in Section 11C of the Act. And essentially, 11C protects employees from being retaliated against if they have engaged in any of the protected activities listed in the Act, which includes filing a complaint, causing an investigation, testifying or participating as a witness in an investigation, or in any way exercising a right related to the OSHA Act. And that last one has largely been interpreted to include refusal to work, provided that the refusal is reasonable and based on a bona fide and reasonable belief in imminent danger to safety or health from pursuing a particular task. So participating in a complaint or an investigation, filing a complaint internally or externally, or exercising a right, including the right to refuse to engage in imminently unsafe activities or tasks, constitute protected activities for the purposes of Section 11C of the Act. So let's talk about the prior test, the test before September 3rd. Really what the law said, again, comes from 11C of the Act. But then the Occupational Safety and Health Administration, in adding more explanation to the statutory language, had published an interpretation. A few different locations, but primarily we see the primary source for interpretation coming in a regulation 1977.6b. And what the agency says in that reg is that for an employee to raise a complaint of retaliation, and for the Occupational Safety and Health Administration, when evaluating that complaint, to find a probable cause that retaliation occurred, there are two ways that a case for retaliation can be established. First, and remember, this is the old rule. First, the agency may find probable cause that the motive for an employer to take an adverse action against an employee included the protected activity as a substantial reason for the adverse activity, the adverse action. Or second, the agency could find probable cause that the employer had terminated the employee because of the protected activity, and that the adverse action would not have taken place but for the existence of that protected activity by that employee. Here, I suppose it's important to point out what an adverse action or what the term means. In general employment law or OSHA law, an adverse action can be anything that includes termination, failure to promote, a demotion, penalties of any kind that affect terms or conditions of employment, such as fines or penalties, or suspension. Disciplinary action that could have a ultimate effect on compensation could also count as an adverse action. Okay, so that's an adverse action, and those are the two ways that OSHA could establish alternatively that there's probable cause that there was a retaliation, an act of retaliation, either that the adverse action that the employer took was based in as one of the substantial reasons for it was the protected activity, or that the adverse action would not have occurred or taken place but for the protected activity. This first one, the substantial reason test, was a significantly lower bar for the agency to establish probable cause. An employee did not need to present evidence that the primary or sole reason for an adverse action was the employee's protected activity. They could merely supply sufficient evidence that, amongst many reasons, one of the substantial reasons was a retaliatory motive. We've put an interesting chart on the slides here. And so for those of you who are listening by podcast later on, I should just point out that the effect of this is to identify the over 20 different statutes that OSHA adjudicates retaliation claims for, including the Occupational Safety and Health Act itself. And the overwhelming majority of the retaliation claims that are filed every year are claims under the Occupational Safety and Health Act, but there's others, including Sarbanes-Oxley, food safety, et cetera. And the number has been essentially, the proportions between all these statutes has been essentially stable with some minor adjustments here or there. So that we talked about the substantial reason for termination as a motivating reason for termination. Taylor, why don't we talk about but-for causation?
Yeah, sure. So this is a test that's used in tort and criminal law, as we note. And essentially, the way to think about this is but for the protected activity. So but for some of those activities that Manesh listed earlier, the complaint, participating in investigation, testifying. So if not for that activity, would the employer have carried out the adverse action? So the firing or the discrimination. So in the context of retaliation claims, the employee must prove that but for the existence of the protected activity, the adverse action would not have occurred. So can it stand on its own? If you remove any other reasoning, is the actual reason that the employee is being either discriminated or discharged from their job because of this protected activity? So that's a way to think about but for causation. For those listening, we have a picture of dominoes here. A way to sort of unpack this that I remember from law school actually is but for the falling of the first domino, would the second domino fall? And so that's just sort of a way to unpack but for causation. And as Manesh mentioned earlier, this is a higher bar than the substantial reason test. So it's harder to prove in a sense in terms of an employee bringing these claims, and so that's something that we'll see what the impact of this is moving forward. But we just wanted to note that certainly more difficult than just a substantial reason that the adverse action occurred.
That's right, Taylor. And perhaps, and this is maybe evident already, but one of the reasons it's harder to prove is because an employer may present the defense that forget about the employee's evidence that this was retaliatorily motivated, his own performance or his or her own performance or conduct or a specific safety and health violation, et cetera, was the reason we would have terminated. And we would have terminated that employee regardless of whether or not there was also a retaliatory motive, because this violation of a safety and health rule or poor performance or conduct was sufficient enough to terminate, objectively speaking. So as long as an employer can establish that under a but-for causation, you can't, an employee can no longer make a but-for case, because even with or without the retaliatory motive, the employee would have been terminated. So you can't say, but for the protected activity, the employee would not have been terminated. Okay, with that said, let's talk about a series of three cases that OSHA cited to, at least two of them are considered landmark cases in the field of employment law. One of them is Gross versus FBL Financial Services. Gross versus FBL Financial Services is an age discrimination act. So it was raised under the ADEA, the Age Discrimination in Employment Act. And the employee brought a retaliation claim after having raised concerns about age discrimination. I apologize, raised an age discrimination claim itself in Gross. And this went all the way up to the Supreme Court. And the Supreme Court said, well, when you look at whether or not to use the substantial reason test, whether or not age was a substantial reason in the adverse action, or use a but-for causation test, meaning but for age, the adverse action would not have occurred, we believe that we have to look at the statutory language in the ADEA. And the ADEA says that it prohibits discrimination because of age. And the term because of is not the same as you'd find in Title VII, which prohibits discrimination for disparate treatment, disparate impact, a host of reasons. Disparate impact cases are essentially strict liability, and the disparate treatment cases, well, although you have to show discriminatory motive, there could be a motive that contributed to a decision. But the Age Discrimination in Employment Act used the term because of age, must not take an adverse action because of age. And for that reason, the Supreme Court held that this term because of is more akin to but for. And thus we believe that the intent of Congress in enacting the Age Discrimination in Employment Act was that an employer is prohibited from taking an adverse action because of age, meaning that but for age, the adverse action would not have occurred. And the burden of persuasion belongs to the employee to meet that but for causation test. Fast forward maybe about 7 years to Nasser, a physician who brought a case against the University of Texas Southwestern Medical Center. Now, remember what I said, Title VII's discrimination, disparate treatment, and disparate treatment claims don't have a but-for causation, and they have slightly different language built into that portion of the statute. So when Nasser brings a claim against University of Texas Southwestern Medical Center for retaliation, the Supreme Court once again must evaluate whether or not to use the because of standard for determining motive or but for standard. And the retaliation language, anti-retaliation language in Title VII uses the term because of the protected activity, which is more akin to the language you find in Gross versus FPL and to the ADEA. Thus, the Supreme Court said, whereas discrimination claims under Title VII use a because of, use a substantial reason test, retaliation claims under Title VII use a but for causation test. And thus the court will find that a plaintiff has failed to make their case. And in the Nasser case, I believe that's exactly what happened, unless they can establish that but for their protected activity, they were, the adverse action would not have occurred. Okay, Nasser was a landmark case when it came out. Bostock versus Clayton County, another Title VII case where the court cited to Nasser, giving us further support for the belief that Gross and Nasser are sound law by the time the Occupational Safety and Health Administration arrives at revising its own interpretation in 1977.6p. Taylor, why don't we talk about the revision?
Sure, absolutely. So it came out in September 3rd, Federal Register notice. And the main thing here is the substantial reason test was removed from this, sort of two-pronged causation test that Manesh touched on earlier. So when you remove that, what you're left with is the but-for causation test that Manesh was just talking about. That was, the subject of the Supreme Court cases. So the employee now must show that but for the protected activity, the employee would not have suffered the adverse action. So again, sort of striking that substantial reason test from what OSHA will look at here. And the employee's engagement in the protected activity, and this is an important point that Manesh will touch on in a bit here, it does not need to be the sole consideration for the adverse action. So you're allowed to have more than one factor, more than one thing that you're considering here. But again, we need to, the employee needs to show that but for this activity, no adverse action would have occurred.
That's interesting. So remember that in the old standard, there were two ways that an employee could establish retaliation. One was that that their protected activity was a substantial reason in the employer's decision to take an adverse action, and the other was that they can say, but for the protected activity, the adverse action would not have taken place. So what OSHA has done on September 3rd is they struck the first one and said now an employee must show that but for their protected activity, the adverse action would not have occurred. What you're saying, Taylor, is a fair point. The agency did add, well, you could have a mixed motive.
Right.
And that means that an employer had multiple reasons for terminating someone, one of which was the protected activity the employee engaged in, which would be a prohibited basis for terminating. But the employee would have to show that there was a mixed motive, and each one of those separate motives was a contributor, without which the other motives would not have stood to lead to an adverse action. That's a tough one. I don't see mixed motive cases being successful, and I think OSHA's opinion may be a little bit out on a limb there. They, I think, wanted to salvage some of the narrowing that they have caused by the September 3rd revision by saying you could still have mixed motive cases, but I frankly can't see that as easy to press for a plaintiff, for an employee. Again, let me just say that slightly differently. An employee, in order to show a mixed motive case under a but-for analysis, would have to say, sure, the employer had two reasons for terminating me, my poor performance and my protected activity. But if my protected activity were not one of the reasons they wanted to terminate me, my performance by itself would not have justified terminating me.
Right.
That's how I think you establish a mixed motive but-for case, but I don't see how that's any different than a single motive but-for case. He's essentially saying the performance argument was a mere pretense, and it's not a bona fide, legitimate, or sincerely held legitimate non-discriminatory reason, non-retaliatory reason. So they put that in there, and again, I think that was maybe just to soften the blow of what I think the result of this is, which is substantial narrowing of the standard for causation. One of the more interesting things about OSHA law compared to all other fields of workplace law is that it doesn't have a preemption clause that covers a non-identical state law if a state has opted out. There's no other scheme that I'm aware of quite like this, where states can opt out and create a state plan that's been registered and approved by OSHA. But such as it is, there are 22 to 28 state plan states, depending on how you count them. So real quickly, I'll not get too far into this, but that marginal 6 states, they apply to municipal or state workers. But for at least 22 of the state plan states, private employers are covered under the state OSHA regimen rather than the federal OSHA regimen. And so OSHA addresses how the revision to its causation standard affects state plan states. And Taylor, I thought it was interesting. They said that they acknowledge the states have to implement a new rule when OSHA implements a new rule, and that new rule has to be at least as effective as the federal rule. However, they said that the states are not obligated to use the but-for standard if they're relying on state statutory language, which may be different from the federal statutory language. Well, I'd argue that if the state statutory language is identical to the federal language in 11C, that is probably what they're going to have to do is treat this anti-retaliation provision as something that an employee can establish only using a but-for causation analysis.
Right.
And the court also noted that states cannot further narrow the causation standard more narrowly than the but-for causation. Okay, so that's great. I'm not sure any state had any prospect of doing so, but I think the real important point in this provision of the announcement in the Federal Register is OSHA telling the state plan states, hey, you don't have to implement a but-for standard if your state statutory language doesn't require it.
Yep.
Okay. This is an important area. Remember, I started off saying I think this is going to have a profound impact on retaliation claims. Retaliation claims are probably the fastest growing area of wrongful termination suits, not just under the OSHA Act, but generally speaking. And OSHA has been fully swamped for a number of years in their ability to effectively process and respond to retaliation claims. And in fact, that number was already meteoric in its rise up to 2019, and then it just exploded during the COVID period, where employees were filing retaliation claims, essentially alleging either that they had refused to comply with certain practices because they felt like it was unsafe under the COVID exposure environment, or they claimed that they had actually complained about inadequate COVID mitigation protocol at the place of employment, and after that they were treated differently. And so OSHA was swamped during this past 18 months to try and handle all of these new claims on top of the existing already large baseline of retaliation cases. It's true that in any era, pre-COVID or during COVID, that most retaliation claims do not result in a finding of merit. Out of it, just taking 2012's data as representative, because that's easily procurable, out of almost 3,000 retaliation claims, only 45 claims were found to have merit. In 2018, similar numbers, 44 were sent to the Department of Justice for further processing. This is less than, just off the top of my head, certainly less than 3%, I'd say less than 2% of all cases. And that's a very small percentage of cases that the agency finds to have merit, or probable cause of merit, I should be more clear. So in light of this new revision, we will see a narrowing of the standard to but-for causation. And I think that that fraction that the agency finds probable cause that there's merit will go even smaller into even a smaller direction, or a lower percentage of all claims filed. So with that said, what are some practical takeaway items for employers in light of this development?
Yeah, so I think the most important one is the first one that we have listed here, and that's that 11C, this retaliation provision, it does not insulate an employee from being discharged for a legitimate reason. So for employers, if you planned on firing an employee because for tardiness or not getting along with coworkers, any sort of legitimate reason, just because that employee has engaged in one of these protected activities, prior they filed a complaint or they're currently testifying, that doesn't mean that just because that exists that you can't fire the employee, or you can't take one of the adverse actions that Manesh described earlier. I think that's one of the big things here, is that it doesn't mean, oh well, we really wanted to let this person go, but they filed a complaint, so we're not going to be able to move forward with that. So that's one of the things that we really wanted to stress here. As long as, again, back to the but-for causation, it's not the reason. They're participating in testifying or filing a complaint isn't the reason why you're firing them. It's actually based in a legitimate cause.
Yeah, and I think, Taylor, that's one of the reasons why it's important, if you have somebody who is invested in protections under 11C, to work with counsel if an adverse action is imminent, to make sure that it's done properly. Absolutely. And that there's a record demonstrating that this is a non-retaliatory motive supplying the employer's decision to go forward with that adverse action. And for that reason, as you note, it's important on the slide, you note that it's important to document all warnings, all performance problems, any misconduct instances, or instances of insubordination. And I think when you're talking about performance or conduct, it's important to make sure that you do a cross-check of other cases similarly situated, so that you're satisfied. And this is the part the counsel should, hopefully, good counsel should be rigorous in forcing the analysis of, is to make sure that employees who are similarly situated with similar performance problems or similar misconduct warnings were not treated differently, that you're not terminating this employee whereas the others just got warnings or suspension or something like that. That analysis, I think, has to be fairly exhaustive before for an employee who has 11C protections or believes they have 11C protections, because I think that's where the action is in terms of being able to defend that this would fail a but-for causation analysis. Safety and health violations, I think it's, again, critical to document all safety and health violations. Taylor, as we say in the Keller and Heckman OSHA law team, there's no such thing as a verbal warning. I believe every verbal warning needs to be followed up by the supervisor with a record in the supervisor's notes. They don't have to be handed to the employee, but the supervisor does have to make their own note that a verbal warning was given, and that record has to go to file. And unless that record somehow makes it into the file, it does remain just verbal in nature. So all safety and health violations should be documented somehow, even if it's just in the supervisor's walkthrough notes. So once you have that record, again, the analysis has to be conducted as to whether or not employees who also engaged in similar safety and health violations were treated similarly. Was the adverse action treatment the same? Because that, I think, is the best way to neutralize any argument that but for the protected activity, the adverse action wouldn't have occurred. Finally, I would say that the reason for the adverse action has to be clearly documented. And I am less concerned, although I do think it should be clearly communicated to the employee, I'm less concerned about that as documenting it, even if only for internal purposes, because that is going to be the record that the tribunal, whether it's the Occupational Safety and Health Review Commission, the ALJ, is going to test the employer's response by. And so if there's multiple conflicting bases for an adverse action, they'll all be subjected to the same analysis as to whether or not that was reflective of the standard that the employer applied to non-protected employees. So these are the kind of critical analyses that have to be done carefully. And I'd prefer, with your counsel, that will help protect an employer when trying to do the right thing, where it involves an employee who may have protection from 11C type adverse actions. Taylor, that's it for today's OSHA 3030, right on time. That's 30 minutes. More information about occupational safety and health law developments can be found on our website, on our LinkedIn pages. This webinar will be republished as a podcast. Hopefully you've subscribed to the OSHA 3030 on your podcast app, and we'll post it on YouTube as well with the slides and video image. And remember to like or rate the program on your podcast app or on YouTube so that it is more easily searchable by others. And finally, I'll end the way I began, which is a request to forward on this invitation to at least 3 other people every time who are responsible either as in-house counsel or safety and health professionals for compliance with safety and health law at your organization or at other organizations. We'll be back in 1 month, October 27th at 1 p.m. Eastern time, always on a Wednesday, always at 1 p.m. for the next episode of the OSHA 3030 with Manesh, Rath. I want to also point out that we have sister programs, the TSCA 3030 and REACH 3030, and the next episode of those programs will be on October 20th at 1 and 1:35 respectively Eastern time. And stay tuned to this channel to find out more information about the next scheduled FIFRA 3030. We look forward to seeing you again next month. And until then, stay safe.